Okay. Okay, everyone. This is Bilal Sayed. I'm the Senior Competition Counsel at Tech Freedom, and this is our event to discuss whether and why the FTC may or may not have the authority to issue binding rules as appear to be likely, especially on the competition side, in the near future. So we've got a nice group of panelists to discuss this. I'll introduce them and then basically turn the discussion over to them. We'll have some time for questions and discussions with the audience as we go further into the discussion. If you have questions, I think just go ahead and put them into the chat room, and we'll be paying attention and put them to the panelists as we can. So our guests here, in no order of importance or any order, Maureen Ohlhausen, formerly chair and commissioner at the FTC and now senior partner at Baker Botts. Professor Thomas Merrill of Columbia Law School, an expert in administrative law and the type of questions we'll be focused on here. Professor Gus Hurwitz at the University of Nebraska College of Law. Peter Wallison, Senior Fellow Emeritus at the American Enterprise Institute. And Baron Skozia, President and founder of Tech Freedom, the proud organizer of this effort. So look, let me frame the question a little bit, but let's jump right into it, right? What does the agency have the authority to issue competition rules? And if they do, what does that mean for us as practitioners, as observers, as firms that may be subject to those rules? And what's the process for getting such things done or undone by over the next few years? I will say that I was the former director of the Office of Policy Planning at the FTC. We looked into this question about whether the agency had the authority to issue rules, competition rules. I don't know that we established the position that the commission, was comfortable with one way or the other. But it was a topic that we discussed seriously. Particularly in the context of non-compete agreements, and we held a workshop on that issue. With that, let me turn this over to Maureen first, and just ask a basic question, maybe to frame the issue or set the issue. Where, if anywhere, does the commission have clear or even ambiguous rulemaking authority?
Thanks, Bilal. I'm delighted to be here. Thanks to Tech Freedom for hosting this. There are areas where the FTC does have very clearly designated rulemaking authority, granted rulemaking authority from Congress, which is where we need to be looking for the source of all authority. So when you look at, for example, the Children's Online Privacy Protection Act or the telemarketing sales, the TCPA, the FTC has been given by Congress the authority to do notice and comment APA rulemaking, right? So Congress knows how to grant that authority to the FTC when it wants to. Then you had a number of years ago, so the FTC for many, many years never claimed that it had rulemaking authority. In fact, disclaimed clearly, said we don't have it. But then it in a case called National Petroleum Refiners Association, we can get more into that, asserted, before the case, it asserted that it had rulemaking authority from this very thin read in the FTC's organic statute called 6G, which simply states the FTC shall have power from time to classify corporations and to make rules or regulations for the purposes of carrying out the provisions of the FTCF. And this wasn't even in the, structurally in the enforcement area of the FTC statute. So we can talk more about the petroleum refiners case, which challenged the FTC's ability to promulgate these rules. But the fallout from that case was that the Congress stepped in and clearly gave the FTC the authority to promulgate rules for unfair and deceptive acts or practices. So just so people know, the FTC has two main statutory missions: unfair and deceptive acts or practices, which is its consumer protection authority, and unfair methods of competition, which is its competition authority. So Congress, in response to this case, clearly gave the FTC UDAP rulemaking authority and put in place a lot of procedural restrictions and extra hurdles for the FTC to promulgate rules pursuant to that. Now, the FTC promulgated a whole lot of rules pursuant to that and got in further trouble with Congress, and they put a few more restrictions on top. But that's the basis for the clear statutory authority for the FTC to engage in rulemaking. Those particular, COPPA, those kind of statutes, and the Mag-Moss rule, which is limited to unfair and deceptive acts or practices. Notably, the Magnuson-Moss Act says it did not say anything about the FTC's unfair methods of competition rulemaking. It was simply specifically silent on that.
Can I ask you, but others, of course, can chime in, has the commission really attempted to make rules with respect to unfair methods of competition in the past? Sort of a core question. I think thinking about their ability to exercise this authority or, potential authority now, and what happened? So
it promulgated one rule it never enforced involving tailored men's and boys' clothes. Interestingly, I'm sure we all remember the big furor over tailored men's and boys' clothes. I mean, how could we have forgotten? And the Octane Rule, which is what was challenged in National Petroleum Refiners, which was not a standalone unfair method of competition rule. It was a hybrid. They tried to say it was a combined unfair and deceptive acts or practices and unfair methods of competition. So even once we had the decision in Petroleum Refiners and the Mag-Moss Act, the FTC has never since then attempted to do a UMC rule.
Okay, interesting. So can I ask you, perhaps, where do you think the FTC is headed? Right, we've had in the last few months, they put out for comment or asked for comment on two petitions filed by the Open Markets Institute, one with respect to rulemaking on non-compete agreements, one with respect to a petition for rulemaking on prohibiting in certain conditions exclusive agreements and all. The agency itself has not proposed anything yet, but what is your sense, and maybe others have a feel for this, of where the agency's going?
Well, Chair Khan wrote an article that expressed her view that the FTC has UMC rulemaking authority and that it is subject to Chevron deference. These petitions from the Open Markets Institute have gotten, she's really highlighted those and created this process for the public to weigh in on them. When you read the petition from Open Markets, it's very supportive of doing UMC rulemaking. And so it seems like we're moving towards a next step from the commission at some point to attempt to promulgate some unfair methods of competition rules. And I will mention, unlike the extra provisions in place for UDAP rulemaking, the chair believes that they are subject only to notice and comment rulemaking under the APA, which is quite streamlined. So I think we will see, likely to see some proposals for the FTC, issue, just kind of a streamlined APA rule under UMC.
Okay, interesting. Now, I think, as you said, you're skeptical that the agency has this rulemaking authority. Professor Hurwitz here, I think, has a different view. So maybe we introduce him to the conversation and ask, right? Why, Professor, do you think the FTC does have substantive rulemaking authority?
Thank you, Bilal. Thank you, Baron, for this discussion. And I'm a professor, so I get to say incoherent things like I believe that it does, shouldn't, and doesn't have this authority. I think today, and I'll outline why in a moment, as a matter of current precedent and law, the agency does have this authority and would get broad discretion. I think it shouldn't. And fortunately for me, I expect that one of two things will happen when the FTC unfortunately does attempt to exercise this authority. Either the courts will agree that it does and they'll vindicate my view that under current precedent it does, or they will change existing law and say that the FTC doesn't, in which case my normative priors will be satisfied. So tails, I win, heads, you lose. The basic reason that I think the FTC has this authority is because the courts have said that it does. In 1973, Petroleum Refiners, the DC Circuit, said under Section 6G that the agency does have the authority to issue substantive rules. Nothing has happened since to change that as a matter of law. Baron, I know, will disagree with that, and we can talk about why when the Magnuson Act says it doesn't change anything with respect to UMC rulemaking authority, that means that Congress wasn't changing anything with respect to UMC rulemaking authority. And on the precedent side, we have since...
We're having some trouble with your audio there.
Okay, Baron is shaking his head. You can hear me fine, or you cannot hear me? Okay, I sound fine according to the chat. Subsequent to Petroleum Refiners, subsequent to Magnuson, subsequent to all of that, we have a long line of Supreme Court precedent, which has tended to support broad agency authority, both in this area and adjacent to it. So obviously we have Chevron come along in the 1980s, and over the course of the 80s and 90s, the Chevron revolution, giving broad deference to agencies over everything from how they interpret rules to even the scope of their own delegated authority. And then we have AT&T v. Iowa Utilities Board, in which the Supreme Court interpreted the Communications Act's almost identical language and said that it gave the Federal Communications Commission substantive rulemaking authority. There are some differences between the acts that we can pick nits over, but the operative language is basically the same. So the most recent Supreme Court case on point vindicates the DC Circuit's Petroleum Refiners opinion. That said, deep breath, that was 1990. A whole lot has happened, 1999, a whole lot has happened in this area over the last 20 years. I think Iowa Utilities Board was at the time possibly a bridge too far, and today at least at the outer edge of what courts would accept. I think if Iowa Utilities Board were heard today, the court would not decide it the same way. I think we are in a period of contracting deference to agencies, contracting understandings of agency authority, and the interpretation methods used in Petroleum Refiners are markedly different than the circuit courts would use today. So if that case were heard today, I think it would come out differently. So while the precedent lines up to say, yes, the commission has this authority, I think 5 years ago, it was a close call. 10 years ago, it would have been in the agency's favor. Today, I think it would pretty clearly, and I would not advise the agency to think that it would be given this level of rulemaking authority.
Gus, is it fair for me to ask you to expand a little bit on that, right? What has happened in the, I'll call it in the doctrine or in the cases, or even in the makeup of the Supreme Court and maybe even the appellate courts, that gives you comfort in saying that?
So we should start at the other end of the pendulum swing. The DC Circuit in 1973 was a very different court operating in a very different environment, a much more expansive pro-regulatory environment and court. So we were in a different era. At the time that Petroleum Refiners was decided, there was some widespread understanding, and this is really what drove the decision in many ways, that the FTC had been created to be a powerful regulatory agency and that it was proving feckless and we should give it more power. And there was a way that we could read the statute to give it more power. So the DC Circuit did that. And that really was the far end of the pendulum swing. Over the intervening years and really over the last 2 decades since the peak of Chevron, we've seen growing concern about ideas that agencies can interpret their own ambiguous statutes with respect to the scope of their jurisdiction, with respect to the scope of their authority, let alone with respect to the ambiguity of their statutory grants. So we've been seeing a growing pushback against Chevron, and a lot of that, Bilal, as you hint at, is also just a simple reflection of the makeup of the Supreme Court. There is some political valence to these issues. The conservatives on the court tend to be more skeptical of expansive government authority and agency discretion, tend to be more in favor of executive control over the agencies, not just, so that means presidential control. So we've been seeing a general pushback along really every dimension here.
Okay. Well, let me ask Professor Merrill maybe to pick up. You've written with a colleague, or maybe a former colleague, what I'd say is sort of the preeminent article on this question. You know, there was a spate of rulemaking in both what you might call the progressive and New Deal eras. What was Congress doing then? What were the agencies doing then? And how did Congress signal to agencies both the ability and the interest in having them issue rules, binding rules? Okay, Professor, I think you may be on mute.
Thanks for having me. Yeah, some years ago, Catherine Watts and I wrote a lengthy article in the Harvard Law Review about exactly what the understanding was when Congress intended to transfer legislative rulemaking power to an agency. So in my mind, this is an extremely important issue. There's sort of a broad version of the non-delegation doctrine, which is, you know, debated in legal circles and is maybe going to undergo some kind of revival based on the separate opinions in the so-called Gundy case recently. But there's a more, probably the most serious non-delegation issue, I think, is whether Congress can transfer the power to legislate in the way it adopts statutes to an agency. And this didn't really happen until 1911 in a small matter involving the U.S. Forest Service. And the court in that case upheld the transfer of legislative power to an agency on the grounds that the statute itself made it quite clear that somebody would be subject to a criminal prosecution if they violated a Forest Service regulation about, you know, how to conduct oneself on a national forest. So that gave rise, we argued in the article, to this convention that Congress followed fairly consistently throughout the Progressive era and early New Deal era, that Congress did not understand, that Congress would pass these rulemaking grants all the time, but they were sort of generically written. But the understanding was that if the rulemaking grant was not coupled with some kind of sanction for violation of the rules that were promulgated, legislative rulemaking power was not being given to an agency, just the power to make housekeeping rules, procedural rules, and so forth. And this was followed fairly consistently. It sort of fell apart after World War II, but certainly during the time in which the Federal Trade Commission Act was passed in 1914, this was the received understanding. So if you look at the statute as it was passed in 1914, the only real regulatory power that's given to the commission is in Section 5, where it has the power to issue these have adjudications investigating various unfair trade practices or unfair methods of competition, and to issue cease and desist orders, which it then has to go to court to get it enforced. Section 6, as originally adopted, was empowered the commission to investigate corporations and issue reports to Congress. And that's where the rulemaking grant appears in connection with this power of investigation, but no substantive enforcement authority. So a fairly easy reading of the original statute is that Congress did not grant or did not intend to grant legislative rulemaking authority on the FTC. The subsequent history, I think the Commissioner Olhausen alluded to this, is overwhelming, that this was the FTC's understanding of the act for 50 years almost after it was after the commission was created. The commission never claimed legislative rulemaking authority during this time period. It always engaged in adjudication. And as people will know, there's two old-fashioned, but I think still viable canons of statutory interpretation that say that an agency's contemporaneous interpretation of its statute and a longstanding interpretation of its statute is entitled to increased weight. And under those canons, the FTC's own understanding that it doesn't have legislative rulemaking authority under Section 6G, I think, would be given substantial weight by a reviewing court today, maybe not in 1973 with the DC Circuit and Judge Skelly Wright, but today I think they would. Moreover, there's extensive evidence that Congress, in fact, ratified this understanding. So throughout the not early years, but sort of the 1930s, 40s, 50s, and so forth of the FTC, Congress occasionally granted a specific rulemaking authority to the FTC and in statutes dealing with fur product labeling and things of that nature, very narrow statutes. But Congress clearly understood that if the FTC was going to have the power to issue a legislative regulation, Congress had to give it specific authority, and it did so with regard to enumerated industries. The most dramatic episode involved cigarette labeling. The FTC finally took it upon itself to issue a rule about what kind of disclosures had to be made by cigarette manufacturers when they sold cigarettes. There's a big pushback against this by the cigarette industry. Congress then overrode the FTC's regulation and adopted its own statute in the Cigarette Labeling Act of 1965, which did not give the FTC rulemaking authority thereafter. So I think there was a very powerful argument that Congress ratified this understanding, as well as that the agency's contemporaneous and longstanding interpretation supported the regulation. I could go into detail about the National Petroleum Refiners case. I think it's a pathetically weakly reasoned opinion. It makes a few stabs at talking about what the text of the statute means. It then discusses a bunch of Supreme Court cases interpreting other statutes and other industries. And then it sort of says the legislative history is ambiguous. In fact, the legislative history is not at all ambiguous. And the court was required to post its discussion of legislative history in an appendix in order to make it clear, make it difficult for readers to probe that aspect of the case and see how weak the DC Circuit's opinion actually was. And then to make it all, to cap it all off, you have this Magnuson-Moss Federatory Commission Improvement Act of 1975, which effectively overruled National Petroleum Refiners and specifically says that the rulemaking procedure that it sets forth, which is very much more procedurally cumbersome than the ordinary notice and comment rulemaking in Section 553, that the Magnuson-Moss rulemaking procedure, which has all sorts of congressional notification requirements and oral argument requirements and a higher standard of review by courts, that was the exclusive basis for rulemaking by the FTC, at least with respect to unfair deceptive acts. Now that Congress has not spoken to the other aspect of the Clayton Act aspects of the FTC's authority with respect to rulemaking, but I think this history would strongly incline a court today that was interested in actually interpreting the law rather than making the law to conclude that the FTC does not have substantive rulemaking authority under Section 6G. And I would cite to one case, that's the Brown and Williamson tobacco case versus the Federal Food and Drug Administration, where a fairly similar issue was presented about whether the FDA had authority to regulate tobacco, and the Supreme Court goes into great detail about how for a long period of time, the agency disclaimed this authority. Congress responded with specific statutes granting narrow authority to other agencies to regulate tobacco, and that this clearly establishes a kind of an understanding by the agency and ratification by Congress that it did not have authority over tobacco. I think the court today, a conscientious court today, including today's Supreme Court, would reach the very same conclusion about the FTC's authority to issue any type of subsidy regulation under Section 6G of the original statute.
So, Tom, if I can quickly hop in on that. First, agree 100%, especially on the FDA point. And it's worth noting on the legislative history point, the district court in petroleum refiners decided largely based upon the legislative history, and the circuit court, as you say, largely disregarded that and included this appendix in the opinion. The circuit court also had this remarkable phrase that really goes to how different an approach they were taking to what we would take today. They noted that powers long unexercised are not lost by being allowed to lie dormant any more than non-existent powers can be prescripted by an unchallenged exercise. So that's basically 100% in opposition to the Brown and Williamson understanding, and just demonstrates how different the approach today would be. It's also worth puzzling over and thinking about, since we're law professors, the role of legal education and how judges think about these things and how the FTC thinks about these things, since there is a 15 to 25 year lag. Law students in the mid-1980s through 2000-ish probably were learning the Chenery Doctrine and petroleum refiners as explaining that courts are going to bend over backwards to say if you have adjudicative authority, you should have rulemaking authority because that can be more judicially efficient and administratively efficient. And if you have rulemaking authority, you should have adjudicative authority because you should be able to enforce your own rules. And of course, that's cut from whole cloth. And over the last generation, professors and scholars have been more skeptical of this. So law students who are now becoming the judges and becoming the agency leaders are starting to have these different understandings. So that cyclical nature of how we think about these precedents, I think, is fascinating and important to understanding why the agency might think it has certain powers and how the courts are likely to respond to them.
I could make one more intervention. I don't want to dominate things too much here, but about the Chevron doctrine. I guess I consider myself sort of an expert on the Chevron doctrine. I have a forthcoming book coming out in the Harvard University Press on the history of the Chevron doctrine. The interesting thing is that the Supreme Court itself has never applied the two-step Chevron doctrine to decide a case since 1916. There appears increasingly to be a kind of tacit moratorium among the justices not to say anything about the Chevron doctrine. I think that's because they can't really agree among themselves, or they can't see clearly where the votes are to do something different than what the court did in Chevron. I think the event that precipitates the conservative judges and academics were all gaga about Chevron when it was first decided back in 1984. But I think the decisive event that probably tips the conservative judges, at least over on the other side, was the City of Arlington case in 2013, which held, as Gus has alluded to, that the agency has Chevron authority to interpret the scope of its own authority. That elicited a very powerful dissent from Chief Justice Roberts that was joined by Justices Alito and Kennedy. So I think in 2013, you have this split among the conservative jurists about just how far we're going to push the Chevron doctrine. And I think that split has widened to the point now where Chevron itself is very much in doubt. I would also note that the first two Supreme Court justices that President Trump appointed to the Supreme Court, Neil Gorsuch and Brett Kavanaugh, are distinguished by, among other things, that they have both been very critical of the Chevron doctrine before they were appointed to the Supreme Court. So I think you now have at least 4 justices, probably with Clarence Thomas, who had an epiphany in 2015 and decided that Chevron is unconstitutional, probably 5 justices on the court that at the very least don't like City of Arlington and the idea that the agency can decide the scope of its own authority. So it seems to me that if this FTC issue got to the Supreme Court, probably the court would not decide it under Chevron. They would decide it the way courts used to decide issues, independently, because it involves the scope of the agency's authority. And for all the reasons we've discussed, the outcome would probably be different from what happened in National Petroleum Refiners.
Well, let me see if we can get Peter Wallison involved here. There's been some discussion about the non-delegation doctrine. Peter, maybe you'd like to pick that up, but as well, you may have other points you want to react to of what Gus and Tom have said, and Maureen. So let me turn it over to you for a little while. Peter, I think you're also on mute. I think you want to take yourself on mute. I think you're still on mute.
While we're doing that, I will just note that we invited Peter.
Can you hear me now?
Yes.
I don't know how I got muted because I say unmuted at the bottom here, but whatever it is. I agree with Professor Merrill's discussion, basically, of the situation today on the question of the Chevron doctrine. But the non-delegation doctrine is really an important and coming issue at the Supreme Court. It is going to be very powerful and influential in the future. Let me just try to make sure everyone understands what it is about. It's the principal protection for the constitutional separation of powers. The Constitution, as you all know, creates 3 different branches of government. Congress is to make the laws, the president and the administrative agencies are to enforce the laws, and the Supreme Court and subordinate courts are to interpret the laws. This, for the framers of the Constitution, was extremely important. Because they were of the view, Madison has expressed in Federalist 47, that, to quote him, people's liberties are not safe if the laws are made and enforced by the same persons or group. So it is important from his point of view, it was important to the framers of the Constitution that Congress only make the laws and not grant to the other branches the opportunity to make laws themselves, and vice versa. Congress is not supposed to execute the laws either. That is for the executive branch. So this structure, when you look at it and look how the court has treated it and is beginning to treat it, since the accession to the court of 2 more conservative justices, it makes it pretty clear that the FTC does not have and could never have, under its existing statutory provisions, the power to make a regulation that is binding as a matter of law. Now, Congress can make the laws. The executive is not supposed to make the laws. How is it that regulatory agencies, as we know, have the power to make laws that are binding, just the same as a law would be on individuals and companies and so forth? It is that way because Congress follows rules, basically the rules that are set out by the Supreme Court about the non-delegation doctrine and what they can do to delegate or to provide to regulatory agencies the kinds of authority that those agencies need in order to make regulations. In the discussion that the tech freedom piece went through, there was very little discussion of this issue. And when you look at it, you'd have to be able to find that on the question of what do we call it? We call it unfair methods of competition. You'd have to see that the FTC actually has authority to deal specifically with that subject in a way that Congress has approved. It doesn't make a difference whether the FTC can or cannot make a regulation. The regulation is only going to be binding if Congress has provided sufficient authority for the FTC to make that regulation. If they have not provided sufficient authority, then the regulation will be struck down by the Supreme Court as unconstitutional, as a delegation of authority that Congress has not approved. Now, let me describe the two different methods that in the past have been used by the Supreme Court to justify regulations that are binding. The first is something that is called let me see if I can find that method here. It's called a well, I have, let me just, excuse me for this. There are two. The first standard that the courts prescribed and permitted was something called an intelligible principle. Congress had to provide to the regulatory agency an intelligible principle that would guide the agency's activities. This came out of a tariff case in 1926, where the court looked at the authority that was given to the tariff agency and concluded that it had provided an intelligible principle that would guide the actions of the regulatory agency in this particular case. That principle has been used quite a lot by the Supreme Court over the years to permit a lot of activity at regulatory agencies that seemed to be going beyond what is permitted under the non-delegation non-delegation principle. And as conservatives began to look at this, including particularly Justice Thomas, there was a thought that there has not been a sufficient technical review of what principles have actually, what powers have actually been given to regulatory agencies. So the court went back to look at a standard that was adopted in 1935 in a couple of cases that struck down rules and regulations under the a law that was passed at that time during the Great Depression, and this law. We'll talk about one of the cases which dealt with the question of whether the agency could control the sale of petroleum. And what the Congress said, what the court said was there were the following deficiencies in the authority given to the agency. It does not, the statute does not state whether or in what circumstances or under what conditions the president may prohibit the transportation of oil. It establishes no criterion to govern the president's decisions. It does not require a finding by the president as a condition of his action. And Congress actually declared no policy about this subject. The law gives the president limited authority to determine the policy for the transportation of oil, or to lay down the prohibition or not to lay it down as he may see fit. This was unsatisfactory to the court because, as they say, from the beginning of the government, the Congress has conferred upon executive officers the power to make regulations. Such regulations indeed become binding, but they are valid only as subordinated rules and when found to be within a framework of policy that Congress has sufficiently defined. A majority of the Supreme Court now seems determined to adopt this stronger version of the non-delegation doctrine against that earlier intelligible principle idea. Obviously, under this standard, something as simple as the power to declare some act as an unfair method of competition without more does not come close to meeting either the original standard, the intelligible principle standard, or the tougher standard that the court adopted in striking down some laws in 1935. So as long as the only power that the FTC now has is to deal with, in a very general way, with unfair methods of competition, just that phrase, it would not have the power, whether it made a regulation or not, to add any additional powers to do anything that would fill out that idea. So, for example, in the paper that Kahn wrote, the idea was suggested that they would issue a regulation on non-competition clauses in contracts. Now, using the power that so broadly stated, which is to deal with unfair methods of competition, that does not have enough particularity to justify something like making a law having to do with the non-competition clauses in contracts. So under those circumstances, it seems to me that the non-delegation doctrine would completely deny to the FTC any kind of regulation, rulemaking that they might make that was intended to be binding as a law on the public or on companies.
Peter, let me get some of our panel colleagues in on this question. Before I do that, a lot of what you said just reminded me of your book that I read a few years ago, Judicial Fortitude. So I'd commend that to the participants and the listeners here. I'd also like to just do a shout out to our group. We're going to end at 12:15, so we have about a half hour left to go. If the attendees have some questions, please put them into the chat room, and we'll see if we can weave them into the discussion. And finally, I'd say somewhat ironically, or just plain funny, of course, you were talking about Panama refiners case, not National Petroleum refiners case, but it's just interesting that two refiner cases play such a role in this question. So let me see. Maybe I'll start with Maureen and then go to Gus, Tom, and Baron if they have any reaction to what we've heard so far.
Yeah, no. So I do want to weigh in on some of the things that others have said, particularly what Peter said about the non-delegation doctrine. I think we're going to talk a little bit more about the AMG case, the Supreme Court's recent decision 9-0. So we're not talking about just, right-wing professors and judges here. A textualist reading, very strict, like, is it in the statute? And the court said the FTC doesn't have the authority to obtain monetary remedies in federal court, and regardless of what the previous court decisions had said on the circuit court level. But the thing that I wanted to point out right now is during the oral argument for the AMG case, Justice Kavanaugh stated, and this is a quote, "With good intentions, the agency pushes the envelope and stretches the statutory language to do the good or prevent the bad. The problem is this results in a transfer of power from Congress to the executive branch on whether to exercise this authority," end quote. So you can see that though AMG was not decided on a non-delegation basis, that those concerns are very much in the minds of the justices, and certainly the Gundy decision, which didn't involve the FTC, had a kind of an extended discussion of that. So I do think when you sort of say, is there an intelligible principle for interpreting unfair methods of competition? The FTC has done it on a case-by-case basis with the whole administrative process and then, court review, appellate court review in there. But to sort of take that and then add on top of that, and it also means rulemaking authority with Chevron deference, I think we'll run into some serious questions should this ever, make it through the court system.
Baron, let me ask you if you've got any thoughts on these questions. I mean, you've waited patiently while we've had this discussion. So jump right in.
Well, first, 2 points of context. Point number one, why this matters. Our legislature is dysfunctional. It is uniquely dysfunctional among Western democracies, and it is incapable of passing legislation. And in the absence of that, it is understandable, though I think not excusable, that many are turning to the Federal Trade Commission and expecting the Federal Trade Commission to essentially make legislation because Congress cannot do so. We've been through this before. We went through this in the 1970s. The only difference is that today it's being done on the basis of unfair methods of competition instead of unfair and deceptive acts and practices. So this is really vitally important. The Commission is going to try to do this, and to the extent that they win in the early stages of litigation, which, as Gus says, is possible because of controlling precedent, they will issue multiple forms of rules. So that's point number one. Point number two, I'm really delighted today to have the group of panelists that we have. I will say that I don't think we've ever been in a situation in Tech Freedom's history in 11 years where we've had all of the right people and really all of the people involved seriously in a conversation on a panel. It was Gus who wrote in 2013 the article that the Federal Trade Commission now relies upon in making its legal arguments. The Federal Trade Commission, the petitioners before the FTC, really have not made their own legal arguments as to why the agency has the authority to make rules here. They really point to Gus and his analysis. So on the one hand, we have Gus, we have Bilal, who ran the question, the process at the FTC to ask whether the agency actually had this authority. We have Professor Merrill, who I think is not given himself enough credit. His paper is not only excellent, it is also enormously comprehensive. He did an exhaustive survey of the legislation that was issued in this period and the cases involving those pieces of legislation to reach the conclusion that he did, that Congress made it clear that it intended to grant the authority to issue binding or legislative rules as opposed to mere interpretive or procedural rules by making clear that the agency could impose penalties for violations of the rules. And of course, Peter has written the definitive book on non-delegation. Maureen is the only other person who I think has been substantively engaged in the debate over whether the agency has this authority. I was very disappointed that in the comments that were filed on these two rulemaking petitions, there were only really 3 other commenters who touched this issue at all, leaving really us and Maureen to get into this in depth. So this is a long way of saying that we really have, I think, a full gamut of the analysis here. And I think it points very clearly to the answers that we've been hearing, which is the agency doesn't have this authority. Now, why? So the question is not primarily, what does the non-delegation doctrine mean today, or where is the court going to go with it, or whatever. That's not how textual analysis works today. The fundamental mistake that the court made, I think, in 1973 in National Petroleum Refiners was not focusing on what textualists ask, which is what was the understanding of the text at the time that the statute was enacted. Today, that's how courts analyze text. Justice Kagan has said, we are all textualists now. That's what she meant. So what matters is not what happens to non-delegation going forward. It's what did Congress understand about non-delegation and other constitutional principles in 1914. And that's why Professor Merrill's convention matters, because I think he argues very convincingly that that is how Congress legislated for generations. Now, to understand that, we can look at what the courts have said more recently. The court has said that Congress does not alter the fundamental details of a regulatory scheme in vague terms or ancillary provisions. It does not, one might say, hide elephants in mouse holes. It would be difficult to imagine a larger elephant than the power to issue legislative rules, that is, rules with the binding effect of law. It would be even more difficult to imagine that when the power at issue is the power to decide that the practice of almost any business in America is unfair. That is to say that the Federal Trade Commission has uniquely broad power, and that has to weigh into the analysis of what Congress intended. Those sorts of judgments about unfairness are judgments that are made, they're value judgments, essentially. They're judgments that are essentially, quintessentially, and profoundly legislative, and they're ones that the Congress has to make because they're the democratically elected representatives of the American people. Now, why do I say that it is so unfathomable that the Congress of 1914 could have delegated such a great power, such an elephant, and put it in such a small mouse hole? Well, we've already heard why this is a mouse hole. It is truly an ancillary provision. It's buried in a list of, quote, additional powers in a provision of the act that governs how the commission does investigations and so on. After Section 5 describes in excruciating detail how the commission is to apply it through adjudication. But we don't just have the text. We also have the Supreme Court itself looked at the FTC Act in 2 other cases in 1935. We talked about Panama Refiners already. That's the case that Peter was referring to. But there are 2 other cases from 1935 that I would call our attention to that were not about this question exactly, but that very much touched upon it. So the Congress of 1914 was deciding to create a wholly new agency and to do something that was really quite radical, quite different from how the other agencies had worked, most notably the Interstate Commerce Commission, which did not have general rulemaking authority when it was first created. It operated case by case. And one of the things that the new Federal Trade Commission did was to create an independent agency whose officers were not readily removable by the president. And that itself was a constitutional revolution. And the court in 1935 litigated that question in Humphrey's Executor. And they ultimately upheld the Federal Trade Commission as it exists. And that's why we still have independent agencies today. But in the process of doing that, they noted that the Federal Trade Commission was created to carry into effect legislative policies embodied in the statute over unfairness and to perform other duties specified therein as a legislative or judicial aid. Now, what did that mean? Well, the court said that the commission simply fills in and administers the details embodied by the general standard, unfair methods of competition, and that the court understood section 6.6, which is the provision we're talking about, as empowering the commission to make investigations and reports for the information of Congress in the aid of legislative power. So it was in that sense, advising Congress, that the court alluded to the Federal Trade Commission as acting as a quasi-legislative body. If the Congress had understood, if the court had understood that the FTC had legislative powers to make legislative rules, the Supreme Court would have noticed. It would have said something about that elephant in that mouse hole, but it didn't. It described the FTC's legislative functions as being just that, just advising Congress. And then also,
Baron, if I can quickly hop in on that point, I want to underline some of the dangers of legislative history and interpretation here, especially when we're talking about opinions that were written actually surprisingly contemporaneous, more contemporaneous with the legislative history can be extra difficult. There was an original proposal for the FTC that would have had it only have investigative authorities and no enforcement authorities in Congress. And that was expressly rejected by Congress, and it was given greater power. So there were different factions in Congress that envisioned the FTC as merely being an investigative and reporting agency, being a enforcement agency, and being a rulemaking agency. So trying to divine the purpose Congress had from the legislative history, the legislature is a group of people, not one person, and the represented views by the court aren't necessarily not cherry-picked to reflect the views that the justices might have had about that.
Well, I agree with you about legislative history. I'm simply describing what the Supreme Court said in 1935. So this is a generation after Congress wrote the act. And the point is that the court upheld what was a really revolutionary move in creating this independent agency where the president did not have what had previously been understood to be the power to remove lower officials for any reason. And the court upheld that, noting and its understanding of how the FTC Act worked. But that is reinforced by the other case, and I'll stop here with this Schechter-Poultry case. This is one of two decisions about non-delegation for 1935, in addition to the one that Peter has mentioned, the Panama refiners case. And in Schechter-Poultry, the court also considered a law that was about fairness. It was about the National Industrial Recovery Act's provision regarding codes of fair competition. And the court in that case distinguished the Federal Trade Commission's unfair methods of competition authority from the National Industrial Recovery Act by specifically noting that what was important about the FTC Act is that unfair methods of competition are to be determined in particular instances upon evidence in light of particular competitive conditions. This special procedure was essentially adjudicative. It went through judicial review. In other words, the Schechter-Poultry court clearly understood, just as the Humphreys Executor Court clearly understood, that what was important about the Federal Trade Commission is that it operated on an adjudicatory basis, case by case. So the question returns to, is it reasonable to think that Congress in 1914 buried into the FTC Act a power to circumvent that process, that adjudicatory process based on particular facts of particular cases, to instead make binding rules that are legislative with effect upon everyone in an ancillary provision? My conclusion is no. Again, that would be a very large elephant in a very small mouse hole. It would violate the convention that Professor Merrill has described because, and this is the most important factual point, Professor Merrill's convention requires that an agency be given the authority to issue penalties for violations of regulations. Not only does the Federal Trade Commission Act not do that, it doesn't even authorize penalties for violations of the act itself in its original form. There's some other provisions today that do somewhat more, but in 1914, when Congress passed the act, the only remedy available to the commission was to get a cease and desist order from a court. Right? That is at the very opposite end of the spectrum of kinds of legislation that Professor Merle described. It's not reasonable to think that Congress in 1914 intended the agency to have the power to make legislative rules.
Let me just add here that most of what I've seen in the memos that you've sent out suggests that you were concerned that making a regulation would change the power and increase the power of the Federal Trade Commission under the general provisions of the Non-Delegation Act, or the non-delegation law, or the non-delegation principle. It doesn't. Making a regulation would make absolutely no difference to the applicability of the non-delegation provisions. So the problem here is that the FTC does not have sufficient legal authority to do anything other than to do what they were provided the power to do in 1914. And to go beyond that, Congress would have to give them a lot more power and a lot more specificity about what they were permitted to do. And if Congress did that, then a regulation could be made that would adopt and expand upon those powers. But right now, they're insufficient.
So Professor Merrill, I want to give you a chance to comment. Barron's mentioned your work. We'll give you a chance to see if you agree or can expand on it a little bit.
Let me make 2 points, one larger and one smaller, amplifying or contesting some of the prior statements. I think in some of my writing, I've stressed this, and also in the forthcoming book on Chevron, it's a big theme that we should draw a distinction between non-delegation and no delegation. Non-delegation is a doctrine that basically says that Congress can't give too much discretion to the executive or administrative agencies, that the delegation has to be constrained by some kind of policy determination that Congress has made which sufficiently limits the discretion of the delegatee. Whether that is consistent with the original understanding of the Constitution or not, I'm not entirely sure myself. I do think that if the court were to adopt that principle today and stick to it, it would cause an enormous upheaval because we have this huge administrative state that's been created it's been given broad discretionary powers. Just and reasonable rates, fair and equitable prices, protection of health with an adequate margin of safety, blah, blah, blah. All these are very broad discretionary grants of power. If they're all unconstitutional, then the administrative state is unconstitutional. And the Supreme Court, whatever's right or wrong as an original matter, ain't going to do that. It'd be like jumping off of a bridge from 50 feet without checking how deep the water is. So I think there's a narrower principle, which I would call the no delegation principle, or maybe the anti-inherency principle, that says that an administrative agency, or for that matter, the President of the United States, can't act with respect to domestic policy, at least, unless the agency or the President has been delegated power to act, period. And so I think the FTC issue can be resolved on the basis of this narrower principle, which is that Congress never gave the FTC the power to issue legislative regulations. And so the agency has no authority to act. It's just like the AMG case that was referenced. The other point I would make, it goes back to the 1935 precedents, and in particular the Schechter-Poultry case, which arose under the National Industrial Recovery Act. Now, many administrative law professors have tried to figure out what principle would support the unanimous decision in Schechter-Poultry to invalidate the National Industrial Recovery Act without also invalidating a whole bunch of issue-specific or industry-specific regulations, which are highly discretionary to agencies. One interesting attempt to do this, and I don't necessarily endorse this, but I throw it out there for your consideration, is by Todd Rakoff, emeritus professor, I guess, at Harvard. And he said that the problem with the National Industrial Recovery Act was that it was an omnicompetent delegation of power. In other words, it gave it gave authority to the president and to these code writers, authority to regulate every single industry in the United States, and to adopt codes of fair practice that would apply to every industry in the United States. And that's different from the typical congressional delegation, which applies to a specific issue area like the environment or a specific agency like the railroads. So I think that the unfair methods of competition delegation to the FTC, if it were understood to include rulemaking, substantive or legislative rulemaking authority, would fall within the category of what Rakoff calls an omnicompetent delegation, and therefore would be suspect under his understanding of the non-delegation doctrine.
So I would love to jump in a little bit here to talk a little bit more about the AMG case, because if we're talking about, cases from the 30s and cases from the 70s, this was like from 2021, right? The Supreme Court looking at the FTC's interpretation of its ability to get monetary remedies and overturning a number of appellate court cases that upheld that. And I think and this was a unanimous decision of the court. And it really, unlike the Petroleum Refiners Court, looked at, Barron already mentioned the elephants and mouse holes doctrine, but it looked very much at the structure of the FTC Act and how there has to be a coherent enforcement scheme, where this 6G authority is located in the statute of the FTC statute, which is divorced from the enforcement section, looking at the historical importance of the FTC's proceedings. The court just decided the FTC can't have a shortcut to desirable outcomes, right? You actually have to go back very carefully to what does the statute say and not take words out of context, and look at the whole enforcement scheme and how all this fits together. So I think, that is such a signal to how, this broad UMC authority that the FTC seems to want to claim now will be treated in the courts. Gus, I have to take issue with you. You said nothing's changed since the Petroleum Refiners case. I mean, I think the whole approach to statutory interpretation has changed very, very much. And in some ways, I find that, the desire to kind of reassert these old powers that, well, I don't even know if reassert, they're barely ever asserted, without taking into account the whole change in statutory interpretation, just seems to me to be an exercise in kind of ignoring the parts of the law of precedent that aren't favorable. So I'm not sure the agency has dealt with that.
I need to hop in there and say, I agree with you completely. Nothing has changed in the precedent of Petroleum Refiners. It hasn't been overturned.
You are correct on that.
Changed. And Iowa Utilities Board, if anything, arguably reaffirms it in a different sort of context, but very similar sort of language. I think the entire way that we look at cases, you're right, has changed. And as I said before, if I were advising clients or I were advising the agency, I would say, don't try it and put rules in place here, unless your goal is to try and force Congress into responding to a bad litigation loss. And that's a whole different kettle of worms.
Oh, and I also just want to mention, Barron, thank you for the endorsement. But my co-author, Jim Rill, who used to be head of the antitrust division, and he is also engaged in these things. And we have this primer on FTC competition rulemaking, pushing the limits. So I want to give Jim his due there too.
Rick, can I do two things? We are just around at 12:12. We're going to go a little longer than 12:15. I want to encourage our attendees to put some questions to us. I've got one here I want to raise. But if as we go around the bend here, if folks have final words, some of our panelists have any final comments to make, I want to encourage them to make them. But let me put this question out to everyone that came in. Assuming the FTC promulgates an unfair methods of competition rule similar to those that are currently under consideration, would we have to wait until the rule took effect and the agency sought to impose penalties on an entity accused of violating that rule or regulation before the issue would be ripe for judicial review? So in short, I think the question is, what remedy, in a sense, do the parties have to challenge the FTC's actions here, and how quickly can they move to that? Maybe Gus, we'll let you go.
So thank you. I actually don't have a response to the question, but as Baron notes, I do need to hop off. So this will be my brief concluding remark, which is mostly thank you. Thank you, Baron. Thank you, panelists. Thank you, participants. This has been, I think, an enjoyable and very informative discussion. And I agree, I think, with everyone, as I was just saying in response to Maureen. You have to have a very, very strained read of current case law and precedent and judicial trajectories to think that the FTC should have or does have upholdable rulemaking authority. I'll add the word upholdable there to bring some agreement. The last two thoughts that I have, I will leave with a professorial, idiosyncratic, and irrelevant question, and also a broader conceptual observation and thought. That observation and thought is that we, as we're thinking about these discussions and topics, most of us are FTC and antitrust focused thinkers, scholars, practitioners. The issues that we're talking about are broader than just antitrust and the FTC. These are big picture administrative law, regulatory, separation of powers, non-delegation doctrine level discussions. And as the courts, especially going up to the Supreme Court, potentially think about them, that's how they're going to be thinking about these issues, not narrow statutes, but what are the arcs of deference? Where's the pendulum swinging? And I think that this pendulum is swinging very strongly against FTC broad grant claims of authority, and more generally allowing agencies to have such broad authority. Echoing many of the reasons that we've discussed, Baron pointed out Congress is dysfunctional right now and incapable of doing anything. And part of the reason for that is because the courts have abdicated their responsibility to tell Congress to do its duty. So it's given a lot of its authority to the executive so that Congress doesn't need to make hard political decisions. Instead, they can just have fun politicking and arguing with each other instead of doing their job. And I think that that pendulum is also starting to swing back. The last curious observation, and this is really a question, I have no idea whether there's any there, but we are in the era of neo-Brandesian antitrust. And I think it is worth noting, going back to Baron's discussion of Schechter Poultry, that Louis Brandeis was both a justice writing for the majority, or he was part of the majority in Schechter Poultry. He was also instrumental in the creation of the FTC. He had notorious fights in 1911 and 1912 with Teddy Roosevelt and Congress over the direction and structure and powers that the FTC should have. And with Schechter Poultry, he had notorious fights with Franklin Roosevelt over the centralization of government and the powers that Roosevelt was trying to accrete to the government over American life. So Brandeis is a thread that runs through everything. I have no idea what to make of that, but I think it is nonetheless at least curious and notable. Thank you all.
Gus, thank you. Let me just remind people of the question we had, which is basically, when would it be right to challenge a rule of this type by the FTC? So let me turn it over to first to Tom, maybe, if he has some thoughts, then Peter, then Baron.
Yeah, sure. Am I unmuted now? Yeah. Yes, I think as the APA was originally understood when it was adopted in 1946, entities that were subject to rules adopted by agencies would have to wait for an enforcement action in order to challenge the rule. They could challenge the rule as part of their defense against the enforcement action. Starting with the Abbott Laboratories decision in the late 1960s, the Supreme Court authorized or permitted pre-enforcement review of regulations. Under a kind of an equitable balancing approach, the pre-enforcement review is available if the entity in question can show that the regulation is going to practically force it to take certain actions which will be irreparable if they comply with the rule, or potentially subject them to enormous penalties if they defy the rule. So it seems to me that it would depend on the content of the rule, but if the rule, directs certain companies in certain industries to take significant actions about restricting their acquisitions or something of that nature, that probably pre-enforcement review would be available. That would be my thought.
Let me just talk about the
Peter,
Congress-
Peter, let me stop you for a moment. I know Maureen has
Yep.
to leave quickly. Let me give Maureen a chance to respond to that, and then we'll come right back to you.
Right. So Tom's understanding totally comports with my understanding as well. If it's going to, you can always challenge the rule as applied to you, but as promulgated, you can also challenge for the reasons that Tom set out. I do also need to leave in a minute, but just to kind of circle back to what was Congress trying to do when it gave the FTC unfair methods of competition rulemaking authority and case-by-case enforcement. And the FTC has actually done a rather good job of developing antitrust law using its case-by-case unfair methods of competition enforcement authority, particularly through its administrative litigation process. And so much of what has happened to the FTC has been in this pursuit of going into federal court and trying to get money under 13B, which is what AMG stopped it from doing, and turning away from this core capability of bringing case by case, enforcement of UMC to give content to that authority. The FTC has, and this has been upheld, essentially has, by incorporation, anything that is a Sherman Act violation is an unfair method of competition. And so when the FTC has proceeded in these ways and having unfair methods of competition and the Sherman Act be coterminous, it has actually made good progress on moving the boundaries of antitrust law in rational ways that gives to the benefit of all antitrust enforcers, including the Department of Justice. So this turn towards rulemaking, which might now be paired with the FTC stepping away from that limited view of unfair methods of competition because they rescinded the policy statement and have made lots of signals suggesting they want to have a very broad interpretation. And then they're going to put that in rules that only FTC can enforce. And they're turning away from a very successful regime of case-by-case enforcement. I think, rulemaking is just part of this, but I think, kind of going back to the mission that Congress gave the FTC is something that I would just strongly encourage everyone to keep in mind, because it's done it successfully. It's moved antitrust law in good directions, and it has done it to the benefit of all antitrust enforcers. So, and obviously to consumers as well. So thank you for having me.
Thank you, Maureen. So let me turn to Peter, and then we're running low on time. So then I'll turn to Baron after Peter.
Yeah, just a couple of points. One is that people have talked about the fact that Congress is not regulating, or Congress is not legislating. It is providing authority to regulatory agencies. That is the reason, I think, that the conservatives on the court have wanted a much stronger non-delegation doctrine, because that would force Congress to deal with some of these issues by forcing them to consider the powers that they are giving to executive branch agencies. This is also going to affect Chevron, because again, the idea is that the courts have allowed the regulatory agencies, the administrative agencies, to move well beyond what powers Congress has given them, as limited as those powers have been and how they've been interpreted. So I think the court is also going to address Chevron. That it seems to me that they're already in the process of doing that, and the next Chevron case that comes before the court will be treated that way. And finally, there was some reference to I guess Barron had talked about the composition of the FTC, and that composition has now changed substantially because in the Saylor decision just a couple of years ago, the court struck down the terms of the members of the FTC. They now all have to serve at the pleasure of the president. And so it's no longer a fully independent agency as it had originally been.
Over to Barron for comments.
Well, again, thanks to everybody for coming. I will just note when former Commissioner Terry Calvani asked this question, he asks, would one have to wait for the agency to seek to impose penalties? Well, of course, the whole point here is the agency doesn't have the authority to impose penalties. If they did, if that's what the FTC Act said, this would be an easy case. That's the point of Professor Merrill's work. And what I think you will find when you look at his article is that the reason there is such a disconnect between the reality of how Congress legislated for the first decades of the 20th century and the way that the courts have decided cases more recently is that convention got forgotten. He tells the story very well, but it resulted in a series of Supreme Court cases that didn't apply that convention. So Professor Hurwitz mentioned several times the Iowa Utility Board case involving the Communications Act. Gus and I are both telecom lawyers. There is indeed a series of cases about the FCC. And those cases are very confusing because Gus was onto something when he said, oh, well, the language in the Communications Act is similar to Section 6G. It talks about carrying out. It looks the same. And one might think that would lead to the same result. But in fact, the key difference is the thing that the court did not pay attention to, the thing that Professor Merrill notes, which is that the Communications Act, plain as day, authorizes the agency to impose penalties for violations either of the Act or of regulations issued under the Act. There is no such provision in the Federal Trade Commission Act. That is the whole point of our discussion today. It is simply supported by these other notions we've been discussing. The non-delegation doctrine was understood very clearly by the Congress in 1914 to make it very difficult for Congress to delegate legislative power and to require that Congress be clear when it does so, hence the convention that Professor Merrill has described. And my point about the removal power was simply to say that in a nutshell, if the Congress of 1914 had actually intended to give the agency the authority to declare something to come across the board, that would have affected an enormous constitutional revolution on multiple fronts. It would have been an affront to the non-delegation doctrine at the same time that the commission was being empowered to do something very new in an independent agency that was supposed to not have its commissioners be easily removable by the president. So it simply is not plausible to believe that the Congress of 1914 buried that constitutional revolution in the mouse hole that is Section 6G. And I'll just close with one last practical point. So what is going to happen? Why is the commission doing this? What is it going to do with the roles that it attempts to issue if it can't issue penalties for violating them? Well, the answer is it's going to say that a certain kind of practice is unfair, like non-compete agreements, and anyone who engages in them or any number of other practices that might be deemed to be unfair has violated the act. And once it's done that, it can then put that company under an order. And then that second order becomes enforceable by civil penalties. That is the way that the commission has worked Historically, that's what's in the statute. What they're trying to do now is make that first step easier to say, aha, you have violated the act. We don't need to show that you did it. We don't need to adjudicate on particular facts or particular cases. We have a rule. You violated our rule. Here is the order saying that you have violated the act. That's what they're attempting to do. That's the end run around Congress.
Let me, we are now a little bit close to 12:30. Let me thank everyone. Let me remind everyone that this is an issue of significant importance, and we at Tech Freedom would like to see, a lot more writing and thinking on this topic. And let me also note that we have two upcoming programs that deal with this issue in the context of the merits of a rule on non-competes and a rule with respect to exclusive agreements. I'll make the point that Maureen made. The agency has been successful in developing antitrust law through the case-by-case method. And something we struggled with, at least I struggled with while at the agency, was if there's a desire for a non-compete, a rule with respect to non-compete agreements, at least as incorporated by employers, why can't we find a case or two to bring before we try to promulgate a rule suggesting these agreements are problematic? So we expect to have in the next few weeks programs on the merits of a rule-based approach to non-compete agreements and exclusive agreements. So we hope people will join those webinars. And again, I'll thank the panelists, and we have maybe give Professor Merrill 30 seconds if he's got some final comments, and same for Peter, and then we'll sign off. But literally 30 seconds.
The only 30-second point I would make is that the Federal Trade Commission Improvement Act of 1975, I think it's called the Magnuson-Moss Act, limits the FTC's authority to issue a regulation dealing with unfair, deceptive acts or practices to circumstances in which it has already issued under its Section 5 powers a cease and desist order. So what this commission is trying to do is flip everything on its head. They want to do rules first, enforcement actions second, whereas the Improvement Act said you can only do a rule after you've done an enforcement act that shows that this is a problem. Reinforcing Maureen's point and Baron's point.
Okay, Peter, let me give you 30 seconds and to sum up and finish off.
All I'd say is that the court is moving in a direction that you'd expect conservative appointees to move, and that is they are going to, I think, eventually develop a case in which 5 members of the court, probably 6, will vote in some way to strengthen the non-delegation doctrine and also to reduce the importance of the Chevron case. Both of those things will force Congress to deal much more carefully with issues that they think have to be addressed.
Oh, okay. Well, let's finish off there. Thank everyone for coming. Thank everyone for participating. I think this was a great discussion. We could probably go for another half day. So I encourage people to do a couple things. Keep up on this issue. Read Tech Freedom's comments to the FTC from a few weeks ago. Read Peter Wollaston's Judicial Fortitude book, and look forward to and read Professor Merrill's book on Chevron deference, and also that article, which although now about 20 years old, is still a seminal article on this issue. So with that, I'll say thank you and goodbye.
Thank you.